So if you're a founder or maybe a developer, you've probably asked yourself this question at some point. Can I actually patent my software? And the answer is yes. But, and this is a big but, the rules of the game have totally changed. So, what does it really take to protect your innovation in 2025? Let's break it down.
To really get why this matters so much, we have to start with a pretty powerful story. On September 10, 2001, Kendra Fitzgerald was this financial powerhouse, right at the top of the World Trade Center. The very next day, the firm was just shattered. They lost over 650 employees. And when the CEO, Howard Lutnick, was asked how they could possibly rebuild from absolutely nothing, his answer was immediate. He said, "I had the patents." That portfolio, that was the one tangible asset that let them hold off competitors and rebuild the entire company from the ashes. It's just a crazy reminder of the real-world power of intellectual property.
So that story really highlights the incredible value of a patent. But look, since the whole .com era, the rules for software have gotten way, way tighter. The core of the challenge today comes down to something called the abstract idea problem. You can't just have a great business idea anymore, slap on a computer at the end of it, and expect to get a patent. The bar is much, much higher now.
So what even is an abstract idea? Well, in the eyes of US patent law, it's a fundamental concept that just can't be owned. Think about things like gravity, or a mathematical formula, or a business practice that's been around forever, like using a third party for escrow. These are seen as the basic building blocks of human ingenuity, and the law says you just can't patent the blocks themselves. And honestly, this is the starting line for almost every single software patent rejection.
The whole landscape was basically turned on its head in 2014 by this landmark Supreme Court case, Alice Corp v. CLS Bank. Now, this decision didn't outlaw software patents, not at all. But what it did was create a brand new two-part test that made getting one a whole lot harder. This case is the reason the game is played so differently today.
Okay, so let's dig into that test. I want you to think of it like a two-door security checkpoint. Your invention has to pass through both of these doors to even be considered eligible for a patent. It's a gauntlet, and every single software and business method patent application has to run it.
All right, here are the 2 steps of the Alice test. Step 1 asks, is your invention really just about an abstract idea? A financial process, a way of organizing information, that kind of thing. If the answer is yes, you move on to step 2. And this is the big one. Does your invention add a true inventive concept? Something that makes it significantly more than just the abstract idea itself. Now you really got to pay attention to this slide, because this is the reality of the situation. For pretty much any piece of software you can think of, the answer to step 1 is going to be yes. The patent examiners are literally trained to find an abstract idea at the core of it, and that's why the entire fight for your patent, all of it, happens at step 2. Everything hinges on your ability to prove you have that inventive concept. So this brings us to the million-dollar question, right? What does significantly more actually mean? What are the courts and the U.S. Patent and Trademark Office, the USPTO, what are they really looking for when they talk about an inventive concept? Let's look at some specifics. This slide illustrates the divide perfectly. On the left, you've got what fails the test every time, just taking a well-known process and saying, let's do it on a computer. Not enough. But on the right, that's what could be inventive. Does your software actually improve the functioning of the computer itself, like making it faster or more secure? Does it use an unconventional method to solve a specific technical problem? That's the territory you need to be in. Let's look at a real-world win. In a case called EnFish, the patent was for a new kind of database. The court said it was patent eligible because it wasn't just organizing information on a computer, it was a specific improvement to the computer's functionality. It totally changed how the computer stored and retrieved data, making it way more efficient. That's a clear technical improvement.
And here's another winner, the micro patent. This was for automating lip syncing in animation. Instead of just automating a task, the invention used this very specific, really unconventional set of rules to analyze audio and generate animation. It solved the technical problem and created a tangible improvement over how it was done before. See, it wasn't just faster, it was a smarter, new technological process.
Okay, so those success stories, they give us a roadmap, right? We've seen the legal hurdles, we've seen what it takes to clear them. So how do we translate all of that into a practical playbook? Let's talk about how you can frame your own solution as a defensible asset that can actually survive all this scrutiny.
Here are the key strategies. First, frame your invention as a solution to a technical problem, like reducing network latency or improving data security. Second, you have to detail exactly how it improves the computer's performance. Third, just like in that McCraw case, define the specific unconventional rules your system uses. And finally, and this is so crucial, your patent application needs to be a technical document, not a business plan. The focus has to be on the how, not just the what.
That all sounds good on paper, but it leads to the next logical question. It's one thing to claim you have a technical improvement, but when you're staring down a rejection from a patent examiner, how do you actually prove it?
Well, there's a really powerful and honestly underutilized tool you should know about, the Subject Matter Eligibility Declaration, or SMSD. Think of this as your chance to formally submit proof. You can bring in expert testimony, performance data, comparative tests, hard evidence that shows your invention is a real technical improvement over what's already out there. It's how you get your proof on the official record.
All right, now let's zoom out. The rules and the tools we've been talking about, that's the current state of play. But the entire system might just be on the verge of a major shift. And it involves a name we heard at the very beginning of this explainer.
That's right. Howard Lutnick, the CEO who rebuilt his company on the back of his patent portfolio, is now Donald Trump's pick for Commerce Secretary. And as Commerce Secretary, he would oversee the entire U.S. Patent and Trademark Office. This quote from his confirmation hearing, it shows he has a very strong, business-first, and kind of protectionist view of intellectual property. He sees the patent system as a tool for American competitiveness.
And he's inheriting a massive challenge. Right now, there's a backlog of over 826,000 unexamined patent applications just sitting at the USPTO. Lutnick has publicly called this number unacceptable and has vowed to bring it down. So that tells us that efficiency and speed are probably going to be top priorities under his leadership.
And all of this brings us to the final critical question for the future. With a results-oriented CEO like Lutnick in charge, someone who has personally seen the power of patents, will his policies strengthen the system for all inventors, startups, and individuals included? Or will the focus on efficiency and big business competition end up favoring the largest corporations? The answer is going to shape the landscape of American innovation for years to come.